Fifth Amendment here, but it's basically arguing against encroachment, all right? So that's one you want to pay attention to when you're coming, especially to things on search and seizure natures. Another good case that you should know is your Miranda versus Arizona. And folks, I'm going to tell you something, and even I can learn something. Not that I'm that much above you. I want to come to you humbly, in humility. I'm telling you, I've read and I know, and there's a lot of things about the law, and I've been my own attorney for over 25 years, and I kick the tail out of them, I'll be honest with you. But I always can learn something, and I'm not stupid enough ever not to realize that. And the next thing I'm going to tell you is probably one of the most important things we're going to tell you today. This is the Miranda versus Arizona decision. It's recorded at 384, volume 384 U.S. That's U.S. Reports, page 436. Now, this is a heavy-duty case. Every American should know this case backward and forward, upside down, and other. All right? Miranda versus Arizona. This is the one that says you got a right to remain silent, you got a right to an attorney, you got a right to have your attorney present during questioning. Anything you say can and will be held against you in a court of law. If you can't afford an attorney, one will be appointed for you by the court. Do you wish to make any statement on your behalf, and you understand the rights that I have spoken to you? As soon as they stop you, talk to you, as soon as they start talking to you, they are required to say that. If they don't say that, they screwed up. If they haul you into jail and they don't tell you this, read it to you, and then they want to make you sign a little statement that you know your rights and you knowingly waived them, please, folks, don't sign that statement. Use your head for something other than a hat rack. Do not sign that statement, ever. You are knowingly waiving your constitutional rights. Don't ever do that. I mean, they don't make it that hard. As soon as you hear those people start talking that, you tell them right effectively, I want to talk to an attorney. And I'm not saying nothing until I talk to an attorney, especially if you're talking to federal people, BATF. These people will lie, cheat, steal. They will do anything they can to hammer you. Their whole purpose in life is to hammer you. I don't want you to think, well, what nice guys, so maybe we can just work this out. Why don't we just talk and maybe we can get things worked out? You don't talk to these people, folks, and you're talking to somebody who learned the hard way. You do not talk to these people ever. I don't care if you think you're a nice guy and you want to be courteous. I don't think you think if you're going to work it out. I don't think you think if you're smarter than they are and you can beat them. I'm telling you, you don't talk to them, period. You button that hatch. An old wise legal defense counsel told me one time, he said, the first rule is keep your big mouth shut. I said, okay, what's the second rule? Keep your big mouth shut. He said, what's the third rule? Keep your big mouth shut. I said, after you follow them 3 rules, the rest is easy. It's when you open your big mouth that you get in trouble. Not that you would do anything wrong anyway, but they'll twist, lie, cheat, and steal and make it into something you didn't do, and before you know it, you won't even recognize what's happened. And I'm telling you, it's happened to me. So I'm telling you as a friend. I'm not telling you as a smart ass or anything else. I'm telling you as a friend. Do not talk to these people. They do not have your best interest at heart. And you may think, well, they're the government, and they're responsible, and they mean well. Well, they don't. They don't mean well. They don't mean you're well, and they will jam you, believe me. And if you're not real good at getting out of it, you can be in a lot of trouble. All right, now, let's look at this Miranda decision. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent, and that anything he says will be used against him in a court of law. He must be clearly informed that he has a right to consult with a lawyer, and to have a lawyer with him during interrogation. Do that, please. And that if he is indigent, a lawyer will be appointed to represent him. All right? If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Don't test that theory. But I'm telling you, it works. I did it. Where the individual answers some questions during interrogation or custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are, in the absence of a fully effective equivalent prerequisite to the admission or admissibility of any statement, inculpability or exculpability made by the defendant, The limitations on the interrogation process required for the protection of the individual's constitutional rights should not cause an undue interference with the proper system of law enforcement, as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. Now, this is the big one, folks. This is the one they're talking about. Did you properly Mirandize him? Was he Mirandized? Was she Mirandized? If they don't Mirandize you, they got to throw the case out. Almost always. It's very hard to go forward with the case if their witnesses are excludable from the presentation of the case. Now, I personally got lucky on this one, folks, and I thought I was really, really good, and I am really, really good. But you want to know something? I have a different standard of equity and law, and I treat everybody kindly, and I basically give them courtesy, and I basically try and be a regular Joe. What happened?
It's okay, just proceed.
A regular Joe, and I basically tried to basically just find out what the heck was going on with this case. I promise you I would never do that again. I would dummy up like there's no tomorrow. I wouldn't say nothing. Not that I do anything wrong, but here's the thing. These people lied so bad. They put so much trash in the record. I was in shock. I couldn't believe that anybody would deliberately do such a thing. But they will. So I'm telling you as a friend, do not talk to these people, especially BATF people. They are not honorable people. They do not recognize the honor you serve. They are not honorable people. Their whole purpose is to hammer you into a position of ridiculousness. So I'm telling you, if they come in to talk to you for whatever reason, I don't care what, you dummy up. You don't say nothing. You got me? You hire an attorney. You get an attorney there and you don't talk till the attorney tells you to. And that's what I'm telling you as a friend, okay? That's Miranda versus Arizona. Now there's 4 Miranda cases. This is the leading case. There is a Miranda warning case that actually locks down the steps of the warning. And then there's a Miranda interrogation case, which locks out the standards for in-custody jail interrogations, okay? Now, a word to the wise should be sufficient, and I shouldn't have to ever say nothing about that again. Believe me, I learned a valuable lesson. You cannot assume that everybody is a good guy. There are some bad ones out there, and I found them. Now, the next case we're going to talk about is Norton versus Shelby County, recorded at 118 volume, United States Reports, page 425. Basically, that says an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is in legal contemplation as inoperative as though it had never been passed, okay? And that's what this case holds, all right? Now, I'm telling you, you go read the case. Don't screw around. If the judge asks you questions about the case, you better know about what it says, all right? Because if he thinks you didn't read it, he's going to throw your case out. The court follows the decision of the highest court of the state in construing the Constitution and the laws of the state unless they conflict with or impair the efficacy of some principle of the federal Constitution or of the federal statutes or a rule of the commercial or general law. The decision of the state courts on questions relating to the existence of its subordinate tribunals and the eligibility and election or appointment of their officers and the passage of its laws are conclusive upon federal courts, all right? Now, some of the most important thing is, while acts of de facto incumbent of an office lawfully created by law and existing are often held to be binding from reasons of public policy. That's a very important point. Public policy. You want to watch out for the terms public policy. It's often confused with the state's right of eminent domain of police powers. Police powers and public policy are almost the same thing, except one's done without law because we wants to, and the other is done because they're claiming a police authority to do so. All right? But when they're talking about public policy, the acts of the person assuming to fill and perform the duties of an office, which does not exist, can have no validity whatever in law. Okay? An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative